would help along with the other remedies which would be available to a person who has been the victim of the police excesses, wrongful detention, and custodial death. We all know that the law within the Constitution, when we speak of Article 21, speaks that you have to have a right. But in certain cases, there are judgments wherein in view of the wrongful detention, custodial death, the courts have granted certain, as they say, initial compensation, and thereafter they say that you can be relegated, and sometimes by applying somewhat the principles where there are deaths, etc., taking cue from the MACT tribunal, etc., then they say that the calculations can be made. Since the topic was quite fascinating, we were trying to get connected with a judge. Before getting live on this platform, we were discussing that his resume as such is an inspiration for many. That I can say that what we say in English, that you have donned so many feathers in the cap, right from Bar Council of India, then Andhra Pradesh Cricket Association, then mayorship, and then above all, as the lawyers, normally one feels even to get designated from Mufsil Court, Tehsil Court, or the District Court, designation is very difficult. In our and in our High Court, also we had two only lawyers so far, and that too way back, who were designated, but they were primarily practicing on the criminal side, and that too in Jalandhar. And his inspirational story that you can even adorn the judgeship if you have created your niche. And I was just reading one of the articles in the SEC Online in September 2020, where itself it gives quite a fascinating journey as such, and principal aspirations. But without taking much time, since I know it also becomes the office hours for the lawyers who are practicing, and also for the students, since the exams somewhere offline and somewhere online is on. I would request, sir, it is always a pleasure connecting with you. We have been connected a lot of times on the WhatsApp or request to sir to share his knowledge. At last, as they say, that good things do come, but they are come to at a destined time. Over to you, sir.
Thank you so much, Vikas. First and foremost, I think I owe an apology to Mr. Vikas. He was very, very persistent despite the COVID, very, very persuasive despite the COVID, and I failed him a couple of times. I gave him my word that I would prepare something or the other, kept coming up, and I could not meet my commitment. So I hope Mr. Vikas would be generous enough to condone the delay and accept my explanation and deem it as a sufficient cause to condone this delay.
So in a writ petition, there is no limitation.
I understand.
No delay and latches as well.
Yeah, but yes, in fact, I would also like to start with a caveat. You know, I grew up my entire life in the beautiful city of Visakhapatnam. I worked in the district courts till I was elevated. So therefore, whatever I talk, the conclusions I come to, or the manner of speaking would be of a trial court lawyer. Therefore, condonation of delay is something that we are used to, although I would accept what Vikas has said, that there is no limitations in the strict sense of the word for writ petitions. I have failed him, and I hope now I am able to live up to the wonderful introduction that he has given. The topic that he has chosen is something that, if I may use the word, very, very topical. This is something that's current all around the world, not only in India, but everywhere else also. Most of I believe some young law students are also online today. Most of you know that there is that movement called the Black Lives Matter, which is happening in the United States. A person called Lloyd George lost his life because of police excesses. And what was his crime? He supposedly gave a fake $20 bill in a store. He was chased down, pinned to the ground. Somebody put their leg on his throat, despite he saying that I cannot breathe. They continued with that action, resulting in his death. The movement called Black Lives Matter got further strengthened, and I also believe it had a very strong impact on the last US presidential election. After that, we had that very, very sad incident in Tuticorin in South India, where a father and son were inhumanly treated and they died in police custody. And what was their crime? They kept open their shop beyond the regulatory hours as fixed by the COVID-19 guidelines. You also had that sad incident in Andhra Pradesh where a young man who was not wearing a mask was caught by the police, taken into custody. Later, he was found dead. 3 of these cases make it very evident that the crimes that were supposedly committed by these people were not so severe as to mandate taking them into custody, let alone subjecting them to third-degree methods, etc. Apart from that, you also have the sad case of a young veterinarian doctor in Hyderabad who was raped and killed. 4 of the people who were found to be, who were alleged to be the accused, were shot dead by the police. This also raises a larger question, whether the police were justified in taking the action that they did. Were these 4 people really the accused? Did they actually commit the crime, or were their lives snuffed out just to appease the public resentment, which was very high? These are all the issues that have happened in the recent past. Incidents that led the right-thinking people to sit back and ponder what is happening in our country. Are police excesses the rule rather than the exception? What is it that we should do as lawyers? Is there an effective remedy on the civil side, more so under the law of tort, to protest and to get compensation or some sort of relief from the courts? If you look at the American example, you will notice that a city like New York in 2019 paid out $175 million as compensation for the police excesses. A city like Los Angeles paid $91.5 million as a result of police excesses. They in fact budget a certain sum of money every year into their police budget to meet the court liabilities or the court decrees. Therefore, while it appears to be good that the people are getting a decrease, the fact also remains that police excesses are not something that are confined only to India. This is a problem that is prevalent throughout the world, and the more advanced nations are not immune from it. Lloyd George's case is a classic example. On camera, when the man was pinned to the ground, when he was saying, "I am not able to breathe, I can't breathe," the policeman continued to pin him down with his leg. So the question that arises is, what is it that can be done? And what is it that is available in India? Mr. Vikas wanted the law of tort to be included in it. Therefore, I found that there are 2 distinct streams of remedies which are available to anybody subjected to police excess. One, of course, is the writ court, the Article 32, the Article 226 method. The other is the traditional civil method. For a failure to take due care, a failure to exercise due caution, and excessive use of force, etc., battery, assault, etc., etc. These are the 2 streams that would be visible to all of us, and hopefully at the end we would agree. I think at least I have come to a conclusion that but for the very vigilant, very proactive steps that are taken by the Supreme Court of India, the Indian law would not have reached the place that it has reached. You have to congratulate the Supreme Court of India for its proactive approach. But at the end of the day, the assessment of damages in our country, unfortunately, is not very, very liberal. Unlike when compared to the West, our assessment of damages is still very conservative, if I may use the word. Unlike in the West, where exemplary punitive damages are awarded, in India, unfortunately, damages are not very liberally. But I still feel and I see a light at the end of the tunnel. Some of the judgments of the Supreme Court, which I'm trying to bring to your notice, are making it clear that exemplary damages, punitive damages can still be awarded. Although in a civil court, this has not yet been done, still the writing on the wall is clear. The directions that are being issued by the Supreme Court time and again make it clear that things are shaping up. And I'm sure one of you youngsters who are listening will be the author of a judgment that would result in granting exemplary damage. If you look into the history of the constitutional courts taking up this issue as a tort and coming to a conclusion that damages should be awarded, I don't know about your generation, but people from my generation the first thing that would come to our mind is the famous case of that Bhagalpur binding. I don't know how many of you are aware of it. Bhagalpur binding was a case where acid was poured into the eyes of the victims by the police. This was the first case that the Supreme Court seriously took up and said we should forge new tools to meet this emerging situation. This happened in 1981. And those are the cases. So those of you who are interested in doing a research into this, you type the word Khatri, K-H-A-T-R-I. You'll find 3 or 4 cases relating to the Bhagalpur blinding. And on the lighter side, this is the Bhagalpur blinding for the youngsters. The movie Gangajal, in which Ajay Devgan acted, is loosely fashioned after these Bhagalpur. This was the first major case where the Supreme Court had to notice these custodial deaths, police excesses, etc., and then decide to award damages. The damages, however, were very nominal. First case that I would like to draw everybody's attention to, as I said earlier, I'm a trial court lawyer. A lot of what I'm going to submit is going to be based upon case law and what I infer from it. Therefore, those of you who are interested may also note down one of the first important cases in this is Rudul Sah versus State of Bihar, 83-4 Supreme Court cases, page 141. 1983, 4 Supreme Court cases, page 141. Many of you are practicing on the writ side also. What is interesting to note in this case is, in 1968, Rudul Sah was acquitted honorably by a court. Until 1982, that is for 14 long years, he was still incarcerated, he was still in prison. 1968, he was honorably acquitted. Till 1982, he was still in prison. A habeas corpus was filed. Once the notice was served, you know what happens. Immediately they released this gentleman and they came before the Supreme Court and said, sir, the writ has become infructuous. The gentleman has been freed. But the Supreme Court did not take it lying down. The Supreme Court wanted to go deeper into the matter and went deeper into the matter. They wanted to know why the man was in prison for 14 long years, despite being acquitted by a competent court of sessions in Muzaffarpur. They gave some explanation saying that he was insane. The Supreme Court took unto itself the task of investigating, went into the depth of the matter, came to the conclusion that the imprisonment of this gentleman was totally wrong. It felt that in these circumstances, the refusal of the court to pass an order of compensation in favor of the petitioner will only be doing mere lip service to his fundamental right of liberty. Thereafter, they awarded some damages, which they said was independent of his right to. If the Supreme Court took the easy way out and felt that he was released, therefore the habeas corpus does not survive, that would have been the end of the matter. But as I said, the Supreme Court did not take it lying down and decided to go further into the matter. The next important case that I would like to bring to your attention, is 1993. 2 Supreme Court cases, page 746. 1993, 2 Supreme Court cases, page 746. The case of, am I visible? Yes. The case of Nilabati Behera. This was another unfortunate case. Nilabati Behera versus State of Orissa. 93-2 SCC, page 746. This is a sad case of a mother writing a letter to the court saying that her son, who has been picked up by the police, has vanished, that his dead body was found 2 days later on the railway track. The police again came up with a story stating that the young man tried to escape. Therefore, he must have been hit by a running train and that the injuries sustained by him or the cause of his death was his attempt to escape. The Supreme Court again did not take it lying down, again took up the issue, investigated the matter, got a doctor to look into the cause of the death, looked into the injuries on the body of the deceased, and then came to the conclusion that the death was due to police excesses and the death was in police custody. What was interesting is an argument that the government has sovereign immunity was also advanced. They tried to escape their liability by saying exercise of police duties is a sovereign function, therefore sovereign immunity applies, and that the state cannot be held to be liable. The Supreme Court negated the contention of sovereign immunity and held that this sort of a plea is not a defense to a constitutional remedy under 32 and 226 for contravention of fundamental rights. In this case, that they started importing the principle of strict liability, and they said the state is liable to pay damages. However, they sounded a note of caution and said the remedy available under 32 for damages is independent of a right to sue for damages under the general law of the land and under tort. Therefore, the Supreme Court said that this remedy should be given more quickly to the poor, the have-nots, who have, as it is, deprived of various rights in this country. Therefore, the Supreme Court awarded a sum of rupees 1,50,000 as compensation. This was for the death of the youngster. Full stop. It was clearly held that the relief of monetary compensation as exemplary damages in proceedings under 32 or 226 for established infringement of indefeasible rights guaranteed under 21 of the Constitution is a remedy available and is based on the strict liability for contravention of the right that is available under 21 of the Constitution. These are the two landmark judgments where the Supreme Court started looking into the questions of custodial death, torture, etc., and coming to a conclusion that merely because they are deciding a dispute under 32 or a high court is deciding an issue under 226, they are not powerless in granting compensation. When they find that the right under 21 has been flouted with impunity, as in most cases, the court is not powerless in awarding damages. The next important judgment, which I would like all of you to make a note, is D.K. Basu versus State of West Bengal. Most of the lawyers who are practicing on the criminal side would be aware of this. 1997 1 Supreme Court cases, page 416. 97 1 Supreme Court cases, page 416. This is a case where Dr. Manoj Singhvi was appointed as an amicus curiae. This is the case where he assisted the court and the court gave this famous D.K. Basu guidelines on how an arrest is to be effective. What are the procedural and other safeguards that should be followed? This is a case dealing with torture, custodial violence, and it is important for more than one reason. This starts, D.K. Basu is an ongoing effort by the Honorable Supreme Court of India. Even now, most of you who are following the law as it develops would know, Supreme Court is still trying to install cameras in police stations, cameras in prisons. Sorry, Mr. Vikas, you are trying to say something? This D.K. Basu started the trend. The Supreme Court is still trying to follow it up. D.K. Basu is important for those who want to file civil suits for wrongful arrest. This case sets out in great detail what needs to be followed by a police officer when making the arrest. It is for this reason, this may often be the foundation of a case or the foundation of a plaint for wrongful arrest, wrongful detention, etc. Kindly keep this in mind. The second D.K. Basu case and the subsequent cases thereafter are all which have developed on this and have tried to bring more and more reforms to prevent custodial deaths. After that, one of the most important and landmark judgments of the Supreme Court of India, a judgment which has opened the doors in my mind to sue the state or the police for damages, is the judgment of the Supreme Court in Municipal Corporation of Delhi versus Upahar Tragedy Victims Association. This is reported in 2011, 14 Supreme Court cases, page 481. 2011, 14 Supreme Court cases, page 481. This case is important for more than one reason. For those of you who belong to the next generation, Upahar was a very famous theatre in Delhi. A very popular movie was released, and on that day, on one fateful day, the theatre caught fire. 59 people died, 103 were injured. This was the theatre built by the Ansal builders of Delhi. One of the brothers was sent to prison under the criminal side, but on the civil side, if you look into it, this is a landmark decision wherein the Supreme Court, this is Municipal Corporation of Delhi versus Upahar Tragedy Victims Association, 2011, 14 Supreme Court cases, 481. It was a series of unfortunate incidents that left 59 people dead and 103 injured. A combination of factors. Oil from a generator came out. The parking area was reduced. 2 cars caught fire. The fumes from the fire went up the AC vent. Extra seats were provided by the theatre owner to accommodate more patrons. More people were sitting. The foam, etc. in the theatre caught fire, as a result of which there was a disaster that was beyond all known proportions on that day. In this case, Justice Ravindran and Justice KSP Radhakrishnan went deeply into this issue of liability, strict liability, and carved out what is now known as the constitutional tort. In fact, if you look at the editorial of the Supreme Court cases, this is what the editor says. He says the new constitutional law, public law tort of breach of public safety duties crafted herein by Justice Radhakrishnan as an independent tort within the larger class of tort of breach of statutory duties humbly submitted is not only a landmark development in Indian public law, but in public law per se, and even in tort law. This new tort crafted by Justice Radhakrishnan has many merits. For the first time, the breach of a duty, the breach of a statutory duty, the breach of a regulatory duty were separated. I mean, when we go to the theatre, when we are sitting, we expect that all the statutory formalities have been done properly, that the people who were supposed to act have acted normally. Now, suppose there is a breach of a statutory duty. The question is, can you or can you not sue the official? Here, the fire department, the Municipal Corporation of Delhi, the theatre owners were all sued. The tort of negligence was held to be the first type of negligence. The second was a breach of a regulatory duty. And the third, and most important, was the breach of a public safety statutory duty. When you go to a police station or when you are arrested, you expect to be treated well. You have constitutional safeguards, you have other safeguards which are engrafted in law. Suppose these are violated with impunity. Suppose the law says this is how you should treat an under-trial prisoner. This is how you should treat a person facing a trial. This is how you should treat a convicted prisoner. And in breach of that duty, the policeman or the jail guard acts. Are you helpless or is the court powerless? That is the question. All of you who are interested in continuing the study in this area should go through this judgment completely and word by word. If you look at the issues that are raised. The calculation of damages has also been improved in this. The traditional, those of you who are practicing in motor accident cases, etc., would know that the multiplier method is a method that is used to calculate damages when motor accident claims are decided. Now, here the question was there were 59 people dead, 103 were injured. They were from diverse backgrounds. The question was, how do you calculate the damages in each case? What is the standard for assessment of damages? As I said at the very outset, in India, damages are still assessed very conservatively. This judgment gives a ray of hope. It adopts the multiplier method. The multiplier method, which is used in motor accident cases, has now been pressed into service, and Justice Ravindran recommends that this should be the method. Although Justice Radhakrishnan has differed to an extent and said that this is not the correct method, Justice Ravindran's judgment was accepted by Justice Radhakrishnan. So therefore, he came to the conclusion that the proper course would be to award a uniform account, keeping in view the principles relating to award of compensation in public law remedies, reserving right to the legal heirs of the deceased to claim an additional amount. Therefore, if tomorrow you wish to file a case, you wish to pursue a case where you are claiming damages, this is a method that is now available to all the lawyers to assess the compensation. Because otherwise, compensation is very, very difficult to assess. How do you actually determine the loss? How do you actually determine the loss of reputation? Let us say if you're wrongfully arrested and your photo is published in the paper and the next day and in 2 months down the line, you're cleanly acquitted. The yardsticks, particularly in the Indian context, are very, very frugal. Therefore, I would recommend everybody to look into this judgment and follow the judgments like Sarla Verma versus Delhi Transport Corporation, other cases, adopt the multiplier method, and then claim your damages. Apart from this, if it is a case of a breach of Article 21, I would strongly recommend bringing it within the constitutional tort number 3 and seeking punitive damages. You have a constitutional right to be treated fairly. Your life or liberty cannot be deprived except under the due process of law. If it is still so deprived, my suggestion would be you should bring it within the constitutional tort. You should raise an issue that what is guaranteed by the Constitution of India has been flouted with impunity. Therefore, I am entitled to exemplary damages and punitive damages. For calculating these exemplary and punitive damages under the general law of tort, this judgment is, in my opinion, a very, very classic case for you to use. You can rest your case for calculation of damages on this. Yes, Mr. PCS Rao, I'll come to the lower court and suits after I finish with the writs. Definitely, I'll address the issue. There's a question that popped up. The next case that I would like to bring to your notice is the case of Rini Johar versus State of Madhya Pradesh. All active practitioners would have faced this unsavory episode in their lives. Rini Johar was a practicing advocate. This is reported in 2016, 11 Supreme Court cases, 703. 2016, 11 Supreme Court cases, 703. Rini Johar was a practicing advocate. She represented a client. A private complaint was filed against them under 420 and 34 IPC. The police arrested them. A practicing lawyer with more than 20 years of practice and a doctor, both arrested, produced before the magistrate on a very, very flimsy case. 420 read with 34. Matter went to the Supreme Court. Supreme Court looked into the matter and came to the conclusion that the arrest and the action taken by the state were both totally contrary to the law. Ordinarily, this is what the Supreme Court said. They were deeply pained by what happened. Ordinarily, we would have asked the petitioner to pursue the remedy before the High Court. But a disturbing one, the petitioners, while appearing, agonizingly submitted that this court should look into the matter in which they have been arrested, how the norms fixed by the court have been flagrantly violated. Now we have a D.K. Basu, that's the law of the land. D.K. Basu laid down the manner in which an arrest is to be effected, the safeguards that are to be followed. Yet with blatant impunity, a doctor and a lawyer of more than 2 decades standing were arrested. The letter of the law is remaining a mute spectator in our books. And that is why the Supreme Court again interfered, went into the matter, did not drive them to a civil suit, and awarded 5 lakhs as damages each, and directed that it should be paid by the state of Madhya Pradesh within a period of 3 months. I am tracing the law. The next judgment that I would like to bring to your steadily, if you look at the growth of the law and the manner in which the Supreme Court has been awarding damages, starting from Nilabati Behera, which was 1.5 lakhs, we have come to a stage where 5 lakhs was awarded as exemplary damage. The other case I would like to draw your notice is the judgment of Nambi Narayanan, who was that famous scientist in ISRO. This judgment is reported in 2018, 10 Supreme Court cases, 804. 2018, 10 Supreme Court cases, 804. Now, Mr. Nambi Narayanan was a well-known scientist working for ISRO. He was arrested on grounds of espionage, Official Secrets Act. The book was literally thrown at him. And what happened? The Kerala police came to the conclusion that he is guilty. That he is fit enough to be arraigned as an accused. There is enough material against him. The CBI was entrusted with the further investigation because there was a large hue and cry. The CBI exonerated the man completely. A closure report was filed. It was accepted by the court. But by the time all of this happened, the reputation of Mr. Nambi Narayanan, who was otherwise a very famous scientist, took a very, very bad hit. Question is, how can this be compensated? The reputation that a man has is something that he builds over the years. Hours of work, years of steadfast application to his chosen field will bring up his reputation. All of that was destroyed in the span of a few hours when the Kerala police charged him under the Official Secrets Act and he was booked for serious crimes. And what happened? At the end of the day, he was exonerated. Even a charge sheet was not filed against him. The police action, including the action of a senior officer involved in the investigation, was very, very severely criticized by the CBI and by the Supreme Court also. And for the first time, ladies and gentlemen, damages of 50 lakh rupees were awarded. Mr. Rishikesh Singh, I'm coming to your point. You have a very active set of participants, Mr. Vikas. Questions, wonderful questions are popping up. Should the officers be liable to pay? Yes, the officers should be liable to pay. Rishikesh, I don't say no. In fact, if I ever given the chance, yes, the state is vicariously liable, the officers are personally liable. They should be made to pay. The reputation that a man builds over the years is shattered because of one false police report. He's thrown behind bars. To get a bail in such a case, most of you know, an Official Secrets Act, etc. are charged. The time it would take for somebody to get bail. All of this put together damaged his reputation beyond repair. That is why the Supreme Court said 50 lakhs should be awarded as damages, and then they left it open for him to agitate his case in a civil court and claim more damages. They said, we think it is appropriate to direct the state of Kerala to pay a sum of 50 lakhs towards compensation to the appellant, and accordingly, it is so ordered. The said amount shall be paid within 8 weeks by the state. we hasten to clarify that the appellant, if so advised, may proceed with the civil suit wherein he claimed more compensation. We have not expressed any opinion. All these cases that I have been dealing with so far make it clear that the remedy that has been carved out by the Supreme Court under 32 or by the High Courts under 226, bringing a law of tort into mixing Article 21 with the law of tort and awarding damages on the principle of strict liability, makes it very clear that it is an alternative remedy and not the only remedy. Even though the court is awarding compensation, the right of a person to choose to file a civil suit and claim actual damages is still not negative. These are two parallel remedies which are now available. Normally, a writ court would say you have an effective alternative remedy, therefore, we do not want to interfere. But because of the transgression of the law, because of the manner in which the law is being flouted, despite the long line of judgments, the Supreme Court and the High Courts have time and again interfered and awarded compensation under their power, under 32 and 226, leaving it open to the party to pursue his civil remedies for illegal detention, for assault and battery, for defamation, and all other heads under the law of tort to which his case will fit in. So if you trace the growth of law from Bhagalpur bindings, where acid was poured into the eyes of these poor people, to Nambi Narayanan, you will find that the assessment of damages has steadily improved. Today we are in a state where after the Upahar tragedy, after the Upahar case and Nambi Narayan's case, we have a situation where a yardstick for measuring damages is now readily available. Till then, the conventional method of assessing damages. But then in a case of defamation, how do you really assess damages? What is the monetary worth that you can put to a man's reputation? You might think you are the king of the world. The person behind you may think you're an idiot. He may have his own opinions. So the question is, there are these issues involved when it comes to defamation. How far was the libel? How far was the defamation published? How many people have read it? What happened? These are all issues which are wide open. Therefore, when there is a police excess, when there is custodial violence, when there is custodial death, the Supreme Court of India has, over a period of time, taken upon itself the duty and carving out exceptions and awarding compensation. With the Upahar grass tragedy, the Upahar tragedy and Nambi Narayan's case are two cases which I would commend to all of you. I request all of you to read those cases carefully. They give you a clue as to how to frame a regular civil action for claiming damages. The yardsticks, whether it's the multiplier method or any other method, are now available in the judgments that I have brought to your notice. Similarly, there is also the question of mental torture that is involved when the police excesses take place. They need not always physically harm you. If they throw you into a prison without a proper case, and you are shown as an under trial for 15 to 20 days, left in a dingy cell, that itself is mental torture. An issue like this has been considered in 2012, 8 Supreme Court cases, page 1. Here, a sum of rupees 5 lakhs was awarded as damages. The dignity of a person which is snatched away by this false criminal case attracted this heavy damages. I would also like to bring to your notice one very interesting case from Andhra Pradesh. Just give me a minute. This is reported in 2010, volume 5, Andhra Law Times, page 50. 2010, volume 5, Andhra Law Times, page 50. an interesting case of a person who was made an accused. A rice mill was burnt in this case. A complaint was given saying that Mr. X was involved in this crime. He was arrested. Investigation went on. For 30 odd days, he was in arrest. After the investigation went on, the police came to a conclusion that this gentleman was not at all involved in the crime. A charge sheet was filed against other accused, and a charge sheet was not filed against the petitioner in this writ petition. What happened in that day? There are two cases like this. One is a suit, one is a writ petition. In that other writ petition, this is reported in AAR 1989 Andhra Pradesh 235. This is a case of a person who was lodged in a jail. Andhra, certain areas of Andhra Pradesh are faction-ridden areas. So this gentleman complained to the jailer and the police, stating that there is a threat to my life. Please post extra guards and ensure that my safety is there. Despite the threat pointed out, despite the representations given, more than the regular guards were not posted, as a result of which, on one day, there was actually an attack on the jail. These are two cases where people have pointed out that when we lose our life, when we point out these things also, the state did not act. In one case, in a prison, a man complains and states that there is a likelihood of danger to me. Still no action was taken. There was a bomb blast. There are injuries. There is a claim for compensation. These cases are being brought to your notice, where a person is supposed to be an accused. An investigation reveals that he is not at all concerned with the crime. The question that arises is, are you or are you not entitled to damages? In my opinion, you are entitled to damages. I mean, arrest, as they say, bail is the rule and jail is the exception. But in India, unfortunately, the reverse happens. People are first thrown behind bars, then the investigation is slowly started. Jail has become the rule rather than the exception. These two cases also make a very interesting study. A person who's held 30 days is in jail. At the end of the day, there's not even a charge sheet filed against him. A person in a jail complains that there is a likelihood of an attack and no safety precautions are taken. There is danger to loss of life and limb. These are two cases which I'm also trying to bring to your notice and trying to analyze and tell you how the law is changing over a period of time. One more important case that I would like to bring to all of you is a recent judgment of Justice Karol, the Chief Justice of a beautifully written judgment reported in 2020, SCC Online, Patna, 2700. 2020, SCC Online, Patna, 2700. Yes, this judgment, for those of you who are interested in further reading, virtually traces the growth of the law. And this is a case of a truck driver who was wrongfully arrested, of a truck that was wrongfully seized and kept in detention. Even the release of the vehicle, which is normally done on a very easy basis, was not done. Justice Karol traced the entire growth of the law, traced the various options that are available, and then awarded damages of 5 lakhs, holding that the state's action was not correct and that they should be directed to pay the sum of 5 lakhs. This is a judgment which I would request all of you to kindly read. It sets out the entire law. Therefore, when you look at the Article 32 remedies and the 226 remedies, you will notice that the Supreme Court has brought in the principles of strict liability, which is a facet of the law of torts, duty to take care, breach of a statutory duty, failure to take care, negligence, as you all know, the failure to take care. In the Upahar theatre case, they brought in these principles. They brought in the principles of the multiplier method, used the Sarla Verma versus DTC, and brought in those principles for calculating damages. In all these cases, ladies and gentlemen, I would like to reiterate one thing. Your remedy of a regular civil suit is not lost. This is an alternative remedy that is available to you. Both the remedies can be parallelly pursued. You can sue them for illegal detention. You can sue them for custodial violence. All these options are open. Now, some of the questions that have popped up on the screen, I would say this much. Yes, the officers also can be made liable for the breach of their duty. And the officers should be made liable. Not merely can be made liable, I would say they should be made liable for breach of this duty. The state is a mammoth organization. 5 lakhs or 50 lakhs will not pinch them. But when the officer concerned is directed to pay the compensation or the damages for illegal actions, I am sure it will pinch them. Apart from that, you should also ask that the fact that a judgment has been passed against him should also be recorded in his ACR. This would, in a way, serve as a deterrent. Hopefully. I mean, despite the growth of the law, there is no, I don't know what to say. Despite the growth of the law, these actions are still. 2019, the Minister of State for Home Affairs states in Parliament that there are 5 custodial deaths per day in this country. 5 deaths per day in this country. So despite the march of the law, the situation has not eased as it should. The situation has not improved as much as it should. But the fact remains that the courts are taking a very, very proactive role. The courts are awarding exemplary damages. Since the law of tort is the topic that because the other areas, criminal law, most of you would be aware, where the National Human Rights Commission, as somebody has said, has not become very effective. I mean, all these tribunals and commissions which are functioning should be given more teeth. Therefore, there are certain lacunas, but I am not for a moment losing hope. If you trace the growth of the law from Bhagalpur to Nambi Narayanan, the fact remains that the Supreme Court is taking a proactive view. Damages are being offered. This is the law as it grew in the writ jurisdiction. The second part of it, as somebody rightly asked, can you sue for damages? Can you sue for battery and assault? Yes, you can. But if you read all these judgments that I have brought to your notice so far, you would also notice that the Supreme Court has said more than once that the process of suing for damages, the process of realizing the compensation through a regular civil suit is very slow in our country. As we all know, the average life of a civil suit, at least in Andhra Pradesh, is 6 to 8 years. I don't know what the situation is in the first court, at least here. 6 to 8 years or maybe 6 to 10 years. Then the first appeal, then the appeals, and the hierarchy of courts. Therefore, as a palliative measure, as a balm, to use the language of the Supreme Court, they decided that some compensation at least should be given by leaving it open to the party to pursue these other remedies in a regular civil court. The remedy of false imprisonment is a remedy that is open to you. In a case for false imprisonment, all you have to plead and prove is that you were imprisoned. You can simply say it is false. It is for the defendant to come before the court and to say that the arrest or the detention was justified. Therefore, when you make your pleading itself, you're being very clear that what is being, that the arrest or the detention itself is per se wrong. And therefore, you are entitled to damages. Let me make it very clear. This is not a very, very efficacious and a speedy remedy. This is a slow but sure remedy. It depends on the quantity of evidence that you introduce and the quality of your pleadings. I would like to bring one or two cases to your notice to enable you to prepare better when you are faced with such a situation. You have assault and battery. You can sue for false imprisonment. If there are physical visible injuries, definitely you are entitled to sue for damages. Mental harassment, mental torture are all facets of this law of tort which you can bring into these illegal arrests and illegal detention. The mere fact that a man has been wrongfully arrested and not charge sheeted itself was held to be defamation. And defamation, as you know, is a good important branch of the law of torts. The fact that he was arraigned as an accused but not later charge sheeted, and all of this was published in the newspapers, etc., was found to be enough. In one of the cases of Andhra that I have cited before you, there was also an instance of the dead body if you read the facts, they make very interesting reading. When the bail application of the accused was coming up where a man was supposed to have died, a lawyer saw that this man is being charged for the death of Mr. X. So he produced Mr. X in court and told the court X has never died. Therefore, the accused before you cannot under any circumstances be charged. This was a peculiar situation which the judge had to notice. The person who was supposed to have died was actually alive, and he was produced in the court physically. And that man was therefore left. Now the question is, what happened to his reputation in the meanwhile? When you're accused of a serious offense under 302, and ultimately it transpires there is no death at all. These are all issues that you should raise. When you have reputation, when you have a status in society that is badly affected by these false accusations, by the illegal arrests, by custodial violence, these are all aspects that are open to you. I would like to bring to your notice a few cases. The first is a very old case. This is reported in AAR 1948, Aud, page 135. 48 Aud, 135. The reason why I'm bringing it to your notice is because Mr. Vikas tells me that there are quite a few lawyers in this group. This could be a basis for your pleading in case you want to file a suit. In this case, by relying upon Halsbury's laws of England, the judge of the Aud court held the gist of an action of false imprisonment is a mere imprisonment. The gist of an offense of an action of false imprisonment is the mere imprisonment. The plaintiff need not prove that the imprisonment was unlawful or malicious. The plaintiff need not prove that the imprisonment was malicious or unlawful. If he establishes a prima facie case, he was imprisoned by the defendant, then the onus shifts on to the defendant to prove that the arrest was for a justified reason. Therefore, the defendant in a case for false imprisonment will have to prove that there was a reasonable and a probable cause on his part for causing the arrest. Keep this in mind when you're drafting your claim. AAR 1979 AP, page 31, is another case which follows the same line. In a case, it is sufficient if the plaintiff proves that the imprisonment was false, it was caused by the defendant, and if the defendant cannot establish sufficient justification, he would be liable. This is 79 Andhra Pradesh, page 31. Here the petitioner the defendant gave a complaint to the police, and he pursued the matter actively. The fact that he pursued the matter actively and did not merely leave it to the police and the judiciary to cause the arrest was held to be against him. Therefore, they could prove that he instigated the police to cause the arrest. He actively followed the police to arrest the petitioner. Therefore, damages were awarded. This is 79 Andhra Pradesh. And then you have another interesting case. AAR 1999 Gujarat, page 316. 99 Gujarat 316. A truck owner's truck was detained. The truck owner rushes, the driver calls the owner rushes to the Thana. There the constable says, typical, what are your right here to come in? It's my duty, I'll do what I want. the discussion aggravates. The constable takes out a rifle and threatens him. These are the facts. Damages were awarded because a shot was also fired and the man was injured. Therefore, what I am trying to bring to your notice is there have been various cases, varied cases. They can't be put in a straitjacket formula. In a case of a simple arrest, all you have to show to the court is that I was arrested wrongfully. You can plead that I was arrested wrongfully. That the arrest was justified, that it is backed by a valid reason, is what the defendant has to establish. In a case of defamation, you will have to show that you were detained unlawfully or that the accusation against you is false. And in a case like the AP case that I have cited before you, where ultimately the body was not traced, the charge sheet was not filed, the man was let off from the prison, damages were awarded. You also have the case of Nambi Narayanan, which is a classic example. Nambi Narayanan was a case where ultimately the CBI filed a closure report. Closure report was accepted. It was held that the police action was high-handed, the investigation was faulty, and that the loss of reputation was very, very heavy. 50 lakhs was awarded, and he was also told that he could still continue to sue the state for its wrongful action. Therefore, ladies and gentlemen, I think I've taken almost 1 hour. I'm sorry. I want to say this. The march of the law, as far as the writ courts are concerned, in the 32 and 226, are coming to the aid of the regular civil remedies which are now available. Today, the regular civil remedies which are slow, which require a lot of evidence, etc., are there. But as more people who have practiced on the civil side, on the original side, would know, the average life of a suit is 6 to 8 or 10 years in these states. I believe in certain other bigger metropolitan cities, the original side, it takes almost 20 years for a suit to be heard. To have evidence, to have witnesses for 20 up to who will depose in court after 20 years is a very, very tall wish. But that's the law, and we are bound to implement law, follow the law as it exists. So this is the civil remedy is always open. It is slow, but it is sure. But then there are questions of pleading, questions of proof, questions of adequacy of evidence, adequacy of the proper evidence. But in case of writ jurisdiction, the Supreme Court has become more proactive where there is a proven case of high-handedness of any nature. You look at Bhagalpur, was blinding. Nilabati Behera was the killing of a youngster. Rini Johar was the arrest of a lawyer and a doctor. Nambi Narayanan was a scientist who was arrested. All these cases, they went on increasing the damages. And ultimately, as I said earlier, one of the best judgments that has come out is Justice K.S.P. Radhakrishnan and Justice Ravindra. In Upahar tragedy case, they carved out a new area of tort, the constitutional tort. They have given you a guiding light to calculate the loss of income, loss of all other issues that you would raise in a motor accident case. You have been given the option of adopting Sarla Verma and other judgments and claiming compensation on the basis of the judgments that have been. Therefore, even though if you look into the 3 or 4 civil suits that I brought to your notice, damages awarded were very nominal. That is because in India, the law of damages is not taken off as it should. Exemplary damages, exemplary costs, etc. are not awarded. Even though the loss of reputation is very high, if you go to a regular civil suit, the damages will be very, very conservative. Therefore, if at all an issue arises and you are faced with a situation where you have to sue somebody who has been illegally detained or tortured in police custody or otherwise, God forbid those cases should not come, but if they do come, please adopt the double-edged sword. Please file a writ under 226 or 32, get your compensation and also pursue your civil remedy. The civil remedy is slow. The alternative remedy is fast. In fact, mercifully, the Supreme Court has come to a conclusion that both of them can be pursued parallelly. Therefore, this, in my view, is a good, healthy opening that you can pursue. Mr. Vikas, this is what I wanted to say.
It was quite a fascinating session, taking us from the journey of 1981 till date. I will just add that since, in fact, this tortious liability, since we were today only discussing on the police excesses, wrongful detention, and custodial death, rather it has also taken, these cues are also there. Let's assume there is an electrocution case or someone has died in a pit. Same principles of Pranay Sethi and Salla Verma is taking, and rightly what you have said, rather from the civil court. In some cases, they say wherein one can always file a writ petition, and thereafter, at least in Punjab and High Court, they say that qua others you can lead your evidence and then file it.
Yeah.
And there was one judgment out here by Justice Raina of our High Court. That's also Raman Kumar versus State of Haryana, wherein they were also given that a lot of law was developed in that particular case. And I will just take the questions which have come so far.
Yeah.
Dr. Madhukar, one of the activists was unlawfully detained for more than 50 hours, assaulted, tortured, Human Rights Commission inquired and penalized rupees 60,000 after the departmental inquiry. 2 eyewitnesses who were in police custody gave excellent witness against the police. So also the departmental inquiry gave clean check. Rejecting the witnesses were chain snatchers. What will be the way forward?
Sorry.
So he says, let's assume a person has been found guilty in a human rights case, and this question is actually quite big. I'll just take it again. They were penalized, and departmental inquiry gave the clean check.
See, departmental inquiry, departmental proceedings are one thing. Even criminal proceedings are under one. Today, all three are open to you. If you manage, if you have good evidence to show that yes, the whole thing was done unlawfully, it is beyond the scope of his duties, you can write to his superiors to take departmental action against him. You can file a civil suit. If you can bring it within your IPC offenses, you can also sue him. You can also initiate appropriate proceedings. All the three remedies are open to you. If you said you have good evidence, I don't think why all three cannot be followed. All three can be followed. Departmental proceedings, criminal proceedings, and a regular civil remedy for damages.
This is by AZ Savaya. He says the report sought time from the state/police by the Human Rights Commission is pending for almost a year. Since the commission is going slow, what can be done by the complainant for the effective remedy to the victim?
Complaint. If it's the writ court, you bring it to the notice, you look at the dates and tell the court it is being delayed. It's a case of violation of a human right. Therefore, they should give preference. I'm sure the court will be sympathetic. Bring it to the notice of the Human Rights Commission where it is pending, or the writ court where it's pending.
But even in a human rights case, a lot of times the judgments are to the effect that it is only for the purposes of recommendatory authority.
That is, as I said, one of the subjects that they do not have the teeth, the little.
And some of the judgment, it is also written it is a toothless tiger. It can only recommend but not implement.
Bark but not bite.
Yeah. Ravish, can you throw some lights of shifting to an inquisitorial system, and if that could be of any help?
I don't think that will really help. You see, the system per se is working well. There are these aberrations which keep happening. Only unfortunate thing is they keep happening with regular frequency. That's the only system is you don't need to have to go into the inquisitorial system again. This is working quite well. People are doing well. But for
that's true. Ultimately, we have to see in the longer run which prevails. By and large, the effective results are coming. This is by Abid Khan, that the police detain an accused in a police station, but they don't follow the procedures of the CRPC.
Habeas corpus, regular remedy that is available to you.
For habeas corpus, they can also look into that judgment of famous of Rudul Sah plus that Bhim Singh of state and J&K of Bhim Singh.
Bhim Singh, Rudul Sah, all of them.
They are also just like Bhagalpur and all, and they also developed this thing.
Yes.
Tremendous march.
Bhim Singh was that MLA from Kashmir, if I remember.
Yeah. Yes. Where I suppose it was 50,000, where I was in post for 2 days deposition. And same was with Rudul Sah and state of Bihar again.
They're slowly improving. Step-by-step process. Because the
initial teething problems are there. Eventually, the law also evolved with a flux of time.
Yes.
And for the better.
When Union Carbide happened, they did not know how to claim damages, how to award damages on such a large scale. Then they adopted some system that was available from America and then come to our country. Even in Upahar, one of the questions is, my income is 1 lakh per month, your income is 10 crores per month. How do you, both of us are sitting in the cinema theater. How do you calculate the damages? You are 10 crores, I am 1 lakh per annum, you are 10 crores per annum. We both are watching the movie and the disaster happens. Therefore, they have to come up with some rough and ready methods. So these are all evolving areas.
We also had that Dabwali fire incident where in the marriage palace, the fire broke off in the tent house, etc. These are also the damages.
These are all things that will slowly come up.
Yes.
And young lawyers should fight. So therefore, the law will develop. Any good judgment is a product of good advocacy.
Out here, we say that there are only 3 types of lawyers: young lawyer, very young lawyer, and very, very young lawyer. So all lawyers are young as long as they're wanting to learn. And sir, thank you for your insights. It was a pleasure. As they say, good things take time, but very good times shoot up well. It is just like a bamboo shoot tree, which they say for 4 years you don't even know whether it is growing or not. And then
thank you. I hope
for 20 feet high. So we had an excellent session.
Thank you so much. Yeah. I hope I could do some justice, and the delay once again may be condoned.
I said it was within the, there was no need for the application as such. It was well within this thing, as long as the acknowledgements were going. And tomorrow's trend, before we part for the day, social media challenges, checks and balances. That is by Dr. Pawan Dogal, an advocate and internationally accredited cyber law expert. Do stay connected with us on Republic Day at 4:30 p.m. And thank you. Stay blessed, stay safe. And to all those participants who have been watching us live on the Facebook, YouTube, and on the social media of this platform, thank you. And thank you, sir, once again for sharing your insights.